would it have the necessary wherewithal to cover the present transaction? As already said, we are not getting into the facts of the case. We assume that all of you know about it. The whole issue is with reference to the controlling interest of Hutchison SR Limited, which is a domestic company, because the controlling interest passed from one non-resident company to another non-resident company. Whether that would attract capital gains taxation in India, more so capital gains under section 911. Then we have to bring such transaction to tax. These three ingredients are very essential, as already endorsed by the Supreme Court. There should be a transfer, and there must be an existence of a capital asset, and that should have been situated in India. Of course, there is a transfer, there is a capital asset. The whole issue is whether such capital asset is situated in India is an issue before the Supreme Court. There was a debate from revenue that many rights, the whole transfer of, the transaction contains, it's a composite transaction involving various rights, licenses and entitlements, which need to be broken into pieces to see which is lying where, which has been opposed vociferously by the Supreme Court, stating that you can't make any such segregation of the composite transaction. Then once you cannot do that, you need to look at what is getting transferred, and it has been held that it is only transfer of share of CGP Investment, which is a Cayman Island company. So thereby, the argument regarding situation of the asset in India has been negated. So when once these three conditions are not getting satisfied cumulatively, 911 will not come into play. That is what is the decision rendered by the Supreme Court. When we talk about 911, we always have a reference to 52B. 52B talks about how a non-resident will be brought to tax, because section 9 itself is a deeming fiction, and if at all there is a transfer happening outside in the form of a contract, whether such transfer happening outside can be brought into tax in India could be a very valid legal issue, which would be set at rest by the deeming fiction brought in by section 9.1. When once the capital asset is situated in India, irrespective of the formality of contract and entering into the same outside, it would still get taxed because of the deeming fiction. So that is what is the last bullet we have highlighted. But in para 71 of the judgment, Supreme Court took a considered view that the capital asset is shares of CGP Investment, a Cayman Island company, and it is not sale of various entitlement rights and other ingredients of the overall transaction.